There we go. All right, in Everland, California, if if a tenant of many years signs a new month-to-month lease, are they considered a new tenant as the date they sign in the eye of a judge?
If they sign a new lease, and I don't know what aspect you're referring to, but generally it's going to be from when they first moved in. So, for example, if you wanted to terminate the tenancy, since they've lived in that unit more than 1 year, even though they just signed a new month-to-month rental agreement last month, you would still have to serve a 60-day notice to vacate, assuming you're not subject to any rent control. So for most purposes, your rental agreement commenced when you moved in, not the date of the new rental agreement.
Okay, great. Deborah Simmons, how does the federal eviction moratorium that expires October 3rd impact California landlords?
I don't think it affects them at all. Some judges and the Supreme Court has said that it can have no effect. Our wonderful president has issued that knowing that they didn't have the right to extend the CDC order, the Centers for Disease Control order. But I don't think it has any effect in the state of California, so evictions can proceed. Some judges were delaying evictions until was July 30th and then September 30th, but again, most judges are proceeding forward.
Great. And then Felix on YouTube, can local moratoriums extend the moratorium past what is stipulated in AB 832?
Sadly, it can, and that's why there's these lawsuits against the mayor of the city of Los Angeles and also against the state of California. For example, the city of Los Angeles' eviction moratorium doesn't have an ending date. The county of LA did, and that's why they have no right to extend their lease, their eviction moratorium beyond September 30th, 2020. So every extension on the county is technically illegal under the state statute. But the city of Los Angeles had it open-ended. So until the mayor declares that the emergency is over, landlords will be forced to go maybe more than 20 months rent without seeing a dime of rent. And this is the same jurisdiction that hasn't really instituted the rent relief program. So they're telling you can't get any rent. They're telling you your rent's deferred from 1 year from when the mayor declares that the emergency is over. There is no time period from when the mayor is going to declare that it's over. And to add salt to the wound, right now you can't apply for the rent relief program. I think it's just a concerted effort on the part of the mayor of the city of Los Angeles to put every income property owner underwater.
That's what it seems like. It doesn't seem like it's hard to think how anyone in their right mind could do what they're doing without there being an evil intent. Okay, NorCal Cosmetics. Just a word for you. If you're in Northern California, a lot of what Dennis Block has talked about today totally applies to you. There's different people asking different questions here. A lot of it's going to be Southern California based. And next week we will have another attorney that's in Northern California practicing there, and he will also share and answer questions as well. And just like as we were talking earlier this morning, Dennis was saying, well, you have this, people will call in and maybe get different answers from different lawyers, even just within his own company. And he would remind people that, hey, well, there's this thing called the Supreme Court, and you get an issue and you end up with judges that are on either side of it. And they're like the elite, right? And so you'll see just different lawyers, different attorneys will have different takes. And so anyway, next week, come and listen to Beckman, and he'll talk about the state, but he'll also talk about stuff that's specific to Oakland, Berkeley, San Francisco, up in Northern California. So, but anyway, if a tenant is Section 8, they should not be moratorium, as their income doesn't change. the HA office evaluate their income regularly if there is any change? What can be done with Section 8 not paying rent?
Again, we don't know what city, and that does affect the answer. If you're in let's say like a statewide rent control area, then if the tenant's not paying their portion of the rent, all you can do is serve a 15-day notice for their portion of the rent, and the tenant would have to sign a declaration under the penalty of perjury that they're financially affected by the pandemic. If he signs it, then, or she signs it, then only 25% of their share is owed come September 30th. There's no way to really, based on the way the statutes are written, to state, hey, you're on a pension or your income hasn't changed, and therefore you have no basis of not paying me the rent and withholding the rent or your portion of the rent.
All right, and Garnick on YouTube, good to hear from you. When can Los Angeles regular rent increases be issued?
If you're under RSO, Rent Stabilization Ordinance, it's going to be 1 year from when the mayor declares that the emergency is over. If you're not under RSO, in fact, if you're just under no rent control whatsoever, then you have the right to raise the rent. Unfortunately, we're limited based on some crazy governor law to 10% as a maximum in any 1 year period, which you would serve a 30-day notice. If your property is subject to statewide rent control in the Southern California area, it's 5% plus the CPI being 3.6%. So right now you could serve an 8.6% 30-day rent increase notice.
All right, on YouTube, Gloud Jr., AB 832 claims 100% arrears covered. Alameda County paid only last 12 months, July 2020 to June 2021, leaving unpaid March, April, May, and June of 2020. Is there any recourse for the balance?
The answer would be yes. You could serve a 15-day notice, and if the tenant doesn't pay 25% and you've applied to the state under the rent relief program, you could then bring forth an unlawful detainer action for that period of time. If the tenant does pay the 25% for that period of time, then your only other avenue is to go to small claims court or regular civil court come November 1st, 2021. And sue there for the 75% that was due for that period of time.
Okay, great. And then someone up in the Northern California area, are there any AOA Bay Area attorneys? And just like Dennis Block has an article, he does a Q&A every month that we're so thankful for those of you in Southern California. And up in Northern California, we have Richard Beckman that has a legal Q&A, and that article is featured every month. And so Richard Beckman is one. If you look at the magazine, you should be getting the magazine if you're a member. And in the contractors and vendors page, if you look under evictions, there'll be a list there. And there's a lot. There are several up there for you to choose from. And the same goes in San Diego. We have a different, we have someone else that writes that one. And anyway, so I like to look at all the different magazines because everybody covers different things. And so it's just really informative. If you don't, you can always see all the magazines at AOAUSA.com. You can go online and look at it there if you're not getting it. But just want to encourage you to sign up. All right. Mary on YouTube. Amen. Scammers and Newsom, let them do it. It's gross abuse. What about the federal government? Aren't they issuing a moratorium too? Okay, so we kind of covered that one, right? So we're going to ignore it basically. And then Ara on YouTube, please answer this question. Concerns all in the city of Los Angeles. If AB 832 ends, like you mentioned, on September 30th. How would this play out for the city of LA?
Well, we're hoping that the city of LA ends it as of October 1st, and that's what I said, the word hope, because the city of LA is open-ended. So there's really little that can be done if the mayor continues his dictatorial ways of extending this. We're hoping that he comes to his senses. He's now the subject of a lawsuit. If he doesn't, then technically there's no basis of proceeding forward other than to try to get the rent relief program to pay you the missing rent.
All right, here we go. Next one. Okay, Corral K. On 10/1/2021, if rent not paid, does 3-day only include only October rent if other amounts are outstanding?
Yes. At that point in time, we have to deal with, quote, the transition time period and the protected time period and civil debt. But it's going to end, we hope, as of October 1st. That means October 1st, the rent for October is due. Serve a 3-day notice on October 2nd for the October rent only. And then we can proceed forward with a standard eviction.
All right, Helen on YouTube. If tenant doesn't pay rent on September and I didn't give them the Form 401 by July 31st, what can I do?
Well, I would certainly give it to them now. Obviously, it doesn't mean that the tenants can live there forever for free because you didn't give some silly form that the governor created. So get the form. It's obviously on the AOA website. And it's no charge whether you remember or not. That's how great this association is. And just send it now.
Right. Batul on YouTube. Our extra pet now is the reason for eviction. It wasn't allowed before last extension.
You could always evict for pets. You could always evict for extra people. You could always evict for alterations to the premises and nuisance. All of these items you can evict for before and after. The way the code was written was that you couldn't evict for an extra person or for a dog or an alteration if it was related to COVID. Now, Jeff, can you come up with a scenario that you brought a dog in because it was related to COVID? I can't even come up with an example. You could do it on, for example, like an extra person. Let's pretend your kids couldn't go to school, and because of the pandemic, they were home, and therefore you couldn't go to work because you had to watch your kids. Very simple. Therefore, you were out of a job, and therefore you couldn't pay your rent. So if you got someone in to assist you and watch your children, well, in that situation, that would be COVID related. That's the scenario that I came up with, that I brought in the extra person. It's COVID related because I can't go to work because somebody's got to watch my children, and they can't go to school because there is no school at this point in time. But other than that, on what basis can anyone come up with an idea that, gee, because of the COVID, I had to bring in a Great Dane to my apartment? So it's kind of silly. So again, you bring in a dog, anybody wants to call my office, feel free, and we'll start an eviction based on that.
Great, there we go. Okay, Olivia, will you please make sure to differentiate between rent control and non-rent control and how the law affects each type of housing?
Nice open-ended question. Let's see what I can do with that. Generally, you're not under any rent control if you're a single-family home, a townhouse, or a condominium. There are, of course, exceptions, but on those circumstances, you're not under any rent control, which means you don't have to have a reason to evict. If the tenant's on a month-to-month tenancy, you can serve a notice to quit. You can also raise the rent to any level, though the state, through their, quote, Emergency Act, is saying that our anti-rent gouging statute says you can't go more than 10% in any 1 year period. So, of course, you can always evict the tenant and you can always get what you want for the next tenant coming in. So I guess the state in that situation is encouraging landlords to evict as opposed to raising rents more than 10%. I guess they didn't think of that one. So that's dealing with non-rent control properties. If your property is subject to statewide rent control, that is, you're not subject to a local rent control ordinance like Santa Monica or San Francisco or Berkeley or West Hollywood, but you're in a city that doesn't have rent control, but you are more than one unit, multiple units, then you would be subject to statewide rent control. Within the first year, you don't need a reason to evict, as we discussed, and why you don't give a 1 year lease. So in that situation, if it's less than a year, you can terminate the tenancy with a 30-day notice. If it's more than a year, you're going to need to have a reason to evict. I said this in our last webinar, that there is a wonderful way to evict tenants that are subject to statewide rent control, where you're not happy with an 8.6% rent increase in Southern California area. You'd really like to raise it more than that, so you would like to have the tenant vacate. There is a reason to evict that everybody can avail themselves of, and that is the renovation eviction. That's going to be available as of October 1st, 2021. If you have a unit that needs renovation, we can ask a tenant that's subject to statewide rent control to vacate on the basis that we're going to do major renovation to that unit. Major renovation means basically that it takes longer than 30 days to complete and requires a building permit, such as an electrical permit or a plumbing permit, where you're going to basically redo the kitchen or redo the bathroom or both. In that situation, we can serve on the tenant a 60-day notice to vacate come October 1st and ask the tenant to leave. We do have to pay relocation money, but the relocation money is only 1 month's rent. So if you're somewhat depressed with rent on a statewide rent control unit, you never raised the rent and now you're stuck because of the statewide rent control, easy way to get around it. We're just going to do renovation, which you'd probably have to do to that unit anyway to get the maximum rent for it. So we can evict the tenant. You must do the renovation, and then we're allowed to raise the rent to market value. So that's basically for no rent control and rent control versus statewide rent control. Obviously, if you're in a local jurisdiction like Los Angeles or San Francisco, then you're just going to have to comply with that, which means your rent control raises are severely limited. In Los Angeles, it's 0 for 1 year. And you're going to have true good cause, not renovation, true good cause to evict.
All right, Dennis on YouTube. Landlord buys building. Rental agreement states 4 occupants. How can I make the tenant provide me the names of the occupants so I can do an updated rental agreement?
Well, you can't force a tenant to sign a new rental agreement. So if he doesn't want to sign it, then there's nothing you can do. You can't force a tenant to state the names of the people who are there. This should have been given to you by the seller of the property, the previous owner. But sometimes previous owners, and maybe that's the reason why they're selling, don't do their job very well, and they have no idea who's living there. We have clients who buy buildings where the owner doesn't even know what the rent is per month, the previous owner. It's insanity, but it is true. So all you can do is, try to get the information from other tenants, or maybe the manager, or maybe take a peek at any mail coming to them to see the names of the occupants. Our firm has a limited way of determining who's living in a particular unit based on our data searches that we can legally do. But again, you can't force a tenant to sign a rental agreement. If your property is not under rent control, then of course you could tell the tenant, hey, sign this or I'm just going to terminate your tenancy.
All right, on Facebook, Darius, thank you for your question. I served a 90-day notice back in December with termination in March. Is that notice stale, and do I have to reserve the notice, or can I move forward with the original notice?
This is a Section 8 tenant, you said?
It doesn't say that. It just says served a 90-day notice back in December with termination in March.
Okay, assuming the tenant is not subject to rent control, then you would have the right to serve that 90-day notice, assuming you haven't taken any rent past the expiration of that 90-day notice. So if the notice expired and you never took rent after, or maybe the tenant never paid you rent after, we have the right now to go forward with that eviction right this second today. So we don't have to wait till October 1st. If you're in a non-rent controlled area and your tenant is on a month-to-month tenancy, we can serve a notice to quit. We can start the eviction. The only parameters that hinder us is that we can't get a judgment in an unlawful detainer action prior to October 1st. So if we start it now, we're not going to get a judgment prior to October 1st. So that case with that 90-day notice, we don't have to wait till October 1st, sir. We just need to start that case right now. Give us a call.
All right, John Coates on YouTube. Are there different methods for an owner-occupied single-family residence with rooms rented out? Evictions, raise rents. Does it make a difference if 1, 2, 3 bedrooms rented out?
Again, I really need to know what area in the city of Los Angeles, for example. It is totally illegal to rent out rooms. The tenant has no obligation to pay any rent, and the tenant has to be given relocation money to move. If you're in a non-rent controlled area where you rented this house out, which I hope you did, then it is a single family home, so it's still not going to be subject to statewide rent control, and you could terminate the tenancy by just serving a 30 or a 60-day notice to vacate.
All right, here's Joe. I have a tenant in San Gabriel who owes me money for May, July, and August, and May's payment via credit card was charged back. Can we start an eviction immediately since it's unrelated to COVID-19?
You can serve a 15-day notice to pay rent or quit. The tenant's going to have 15 days to do something. The something is either pay the rent in full that's owed, in full, not 25%, but in full that's owed, or sign that declaration under the penalty of perjury that the reason why the rent wasn't paid was due to the pandemic. If you do not get that declaration, if you do not get the rent in full, either of those two things, we have been bringing forth unlawful detainers right now, this moment, to evict those tenants from the property.
All right, thank you. On YouTube, Steve Stern. If a judgment is ruled in your favor, how easy is it to garnish wages or get monies from a bank account?
It's actually really simple. If the guy's working and doesn't quit his job, we have wage garnishments coming. I mean, we get in 6 figures of collecting on judgments per month in my firm. But the issue is there money in the bank account? Do you know where the bank account is? And where is the tenant working? Did he get up and move someplace else? We have probably the best debt collection software where we can determine where people bank, what their social security number is, and where they're working. And if they are, then we can generally collect, and it's a pretty simple process. But in all fairness, if you're a gardener and you work off the back of your truck and you don't have a bank account, then it's going to be very difficult. You're not going to collect. So that 20 months that the tenant owes you is never going to be seen.
Right, and you should, if you're using the AOA rental application and you're requiring them to fill that out all the way, you're going to have their bank information, and it's going to be a whole lot easier. Yeah,
the only problem, Jeff, would be if they decide to move to a different bank after you filled out that application, or maybe the bank is 100% applicable and there's literally 13 cents in that bank account. When
Right.
we do what we call bank levies, and so we'll send out a writ to the sheriff's office with instructions to do a bank levy, and sometimes we'll hit it for $20,000, $30,000, $50,000, but sometimes we hit it for $1.25 comes back as the amount of money that was in that bank account.
Right. All right, here, Meryl on Facebook. Do these rules also apply for commercial tenants? What is the best strategy to collect from a commercial tenant in Burbank who hasn't paid since April of 2020? He just vacated the property a few days ago.
These rules do not apply to commercial. Commercial has nothing to do with the eviction moratorium under the state laws. You'd have to deal with the local ordinance. The county of Los Angeles has a local ordinance. The city of Los Angeles, for example, has a local ordinance. And there are other municipalities like San Francisco, which I believe has one for commercial. Well, since the tenant is left, nothing prevents you right now, this moment, from bringing forth a civil lawsuit for that rent owed. And certainly our firm could assist you with that.
All right, on YouTube, Monica. When in City of LA, tenants will start paying full rent if still emergency is not lifted by King Garcetti?
For the city of Los Angeles, again, there's nothing you can do if they're not paying the rent. You have to wait for the mayor to declare that the emergency is over. Then the tenant will owe the next month's rent, where you could serve a 3-day notice. All the other rent is deferred for 1 year. Unlike the state where it's changed to a civil debt, you can't ever sue for it. Technically speaking, in the city of Los Angeles, let's pretend the mayor ends it. This is kind of a curious situation. The mayor ends it on October 1st. And the tenant owes you 20 months worth of rent. And that rent is deferred based on the mayor's proclamation for 1 year. So he ends it on October 1st, and you got a smart tenant. So he says, hey, I owe you 20 months rent. Here's my October's rent. So can you start an eviction or you're under rent control? The answer is no, because is any rent owed? No, no rent's owed. He paid you October's rent. The other 20 months of rent is deferred for 1 year. But the curious part is, here we come, fast forward to October 1st, 2022. And October 1st, 2022, 20 months worth of rent is owed. And it's not considered a civil debt. It's considered rent. And it's not owed more than 1 year ago because it's not due until October 1st, 2022. So on October 2nd, 2022, you could serve a standard 3-day notice for that rent owed for that 20 months and start a standard eviction, because they don't get the protection because they didn't change the definition to civil debt like the state did. So that's the curious part. So circle that on your calendar, everybody, if you have property, at least in the city of Los Angeles and other municipalities that kind of followed the city rule, that on October 2nd, 2022, give that phone number a call, 1-800-77-EVICT, which is my office number. And we'll start a standard eviction on your tenant for all that rent.
All right, let's see. What do we have here? If I reject the rent assistance from tenant, can I still evict? I don't accept the 80% collect. I want the full amount.
Well, again, under the new rules, you're entitled to the full amount, 100%. And under the new rules, you have to accept, if the government offers the 100%, you have to accept the 100% of your money, your tax dollar money. And then that debt would be extinguished. And if the state doesn't pay you or rejects it or doesn't tell you that they're accepting it within 20 days, then you could go forward. But if you get that rent from the state, the 100%, then you can't go forward with an unlawful detainer. In fact, you're required as part of a declaration in that unlawful detainer to state that I have applied for the rent relief program and it has been either rejected or there's been no decision within the first 20 days.
Right, so just apply for it. Housingiskey.com, right? Just apply for it.
Let's do it. Let's see if we can get some money. I doubt it, but let's see.
Yeah, I still don't know if it's 80% of median income or not. I'm kind of under the assumption that it is, but I definitely could be wrong. And let's see, here we are.
I think we have questions for what, the next 3
yeah,
hours?
you know, this is, we probably, I mean, it's pretty, there's just a lot of questions. And you guys, you know that there's a lot of questions.
Let's go for another 15 minutes worth of questions. How's that?
Okay, that sounds good. Let me see. Now I kind of lost my place here. Michael, for LA City, did you say that delinquent rent for the covered period is deferred for 1 year? Okay, yes, you already said that, yes. Okay. Grace, can we increase rent in LA City right now if property falls under the statewide rent control?
The answer is dramatically yes, you can, and it would be 8.6%. Go to the AOA website, grab their change of terms of tenancy form, and go serve that 8.6% rent increase on every tenant you got.
Here's a good question from Jill on YouTube. I received state money for 100% of past due rent up to June 2021. Hey, look, they're actually alive and out there. Congratulations, Jill. Renters did not pay rent for July and August. What are my options?
Well, I would wait till September, serve a 15-day notice for the September's rent. Did she say this was Los Angeles under rent control?
LA City, yeah.
Okay, so if she's under rent control, then there's little that you can do at that point. You have to wait 1 year from when the mayor declares that the emergency is over.
Okay, Tom has a question. Why is Dennis so sure the eviction moratorium will end on September 30th?
And I'll tell you why I'm so sure. Stop laughing, Dan. Okay? I don't need no peanut gallery over here. The reason is because they built in to the eviction lawsuit that you have to apply for the rent relief. You can't even file an eviction unless you've applied for the rent relief. So that indicates to me that they're saying, hey, look, we gave you every chance, Mr. Tenant, to either pay the rent, we deferred the rent, and now you're forcing the landlord to apply for the rent relief and that he's going to get his rent. So on that basis, I can't see them extending it beyond October 1st, but anything can happen.
Okay, there you go. It's a crystal ball, and we will see. And I'm hoping and praying Dennis is right. Okay, I really am. So definitely get involved in the protest and let's make it happen. Right?
Yes, let's make it happen.
Let's make it happen, and it takes activity. And if we just sit back and spectate and only talk, then we are not exercising our rights as American citizens. And freedom is one of these things where if you don't exercise it, it's like a muscle. You actually lose it. You will lose it. All right, Boardwalk Real Estate. What about the 15-day notice in the city of Santa Monica to get 25%? When is the latest day prior to September 30 that it can be served?
You can serve that right now in the city of Santa Monica. Because their statute is now mimicking the state statute. They'll have 15 days, and then they'll have to pay 25%, as I stated, as of September 30th.
All right, Peter, if your tenant has been in the property for less than a year, can you evict him now?
Again, if you're under statewide rent control, the answer is yes. If you're under no rent control, the answer is yes.
All right. let's see.
In that situation, you'd serve a 30-day notice to vacate. Again, the forms on that wonderful AOA website.
Okay, Lisa Welcher, what are the qualifications for the tenants to qualify for the reimbursement?
I'm not sure. The last one was that you had to earn less than 80% of the median income for the county in which the tenant has resided. I'm not sure what the requirements are based on this new program. But again, if they're giving away free money, that money, of course, being your money, definitely apply for it, ladies and gentlemen.
Okay, I'm just kind of going through. I'm looking for ones that have the city stated. So I am skipping over a few of these. I'm kind of searching. And everybody, gosh, please tell us the city and what kind of unit it is. Okay, on Facebook, can we file a civil lawsuit for 100% of the civil debt owed during the transition time period?
No, you can only go for 25. Well, I take that back. You can go for 100% of the rent for the civil, on a civil debt once November 1st rolls around.
Okay. Peter, if the tenant's 1-year anniversary expired during the protected period, is he now protected from arbitrary eviction?
One more time on that question, Jeff.
If the tenant's 1-year anniversary expired during the protected period, is he now protected from arbitrary eviction?
I mean, if you have the right to evict and you're in a non-rent control jurisdiction, you can certainly serve a notice to vacate. I'm not sure what you mean by arbitrary eviction. You can't evict for an improper reason. For example, you're discriminating against a certain class of people, but other than that, you can always terminate a month-to-month agreement if you're not subject to any rent control.
All right. On YouTube, can you increase the rent in the city of San Diego?
I'm not sure on the answer to that. I think you're under statewide rent control. I don't know if they have their own statute. In fact, I don't think they do. They don't have their own rent control statute. So I think you're under statewide rent control. And again, you'd be able to raise the rent. I'm believing, but and it's actually on my website, Evict123. If you look at the red banner at the top, I believe for San Diego, the CPI for this year is 4.2%. Add that to the 5, so it would be a 9.2% rent increase.
All right, John Brown, the supplemental fee has now been mandated. Anything we can do since we're not allowed to collect owed rent? CSEP fee.
Not sure what you mean by a supplemental fee.
There's that. I think it's a per unit.
Are we talking about like the city of Los Angeles?
Yeah, maybe it's.
I'm not
Santa
sure what he
Monica,
means by that question.
The SCEP supplemental fee.
Oh, okay. Well, that's the special code enforcement program, but that's. Can you collect that? Well, the tenant owes that. That is part of the standard rent. But again, if the tenant is claiming COVID, then he doesn't have to pay it and it's deferred.
All right. Is there a rent freeze in Lawndale and Hermosa Beach?
Okay, both of those jurisdictions do not have local rent control. If you're talking about multiple units, either a duplex or higher, then you're under statewide rent control. And again, you're limited to 8.6% for those areas in LA County. If it's a single family home, then there is no limitation except for the quote anti-gouging provision, which is still on the books for some crazy reason. And you can't go above 10%.
All right, Virginia, for the city of LA, can you evict if there is unauthorized person in the unit? Just received supplemental tax bill code from code enforcement, HCIDLA, another assault on landlords.
That is another assault on landlords. The Housing, Community, and Investment Department. Well, why did they get that name? It's an anti-investment department is what it really is. But yeah, we can go forward on unauthorized persons, even though we get letters from the inspectors from, it's called HCID, the Housing, Community, and Investment Department, that says we can't do it, and we ignore those letters and we just go forward and we do evictions on unauthorized occupants.
All right, Lee Sally on YouTube. Los Angeles under rent control. Can I charge tenants now for smoke detectors, cost recovery, and RSO fees?
Yeah, I mean, these are fees that are owed under the rent stabilization ordinance. The tenant owes it, but if the tenant's not paying rent, then because of COVID, then that rent is deferred, be it the small fees and the main rent. It's deferred for 1 year.
Okay. Ellis Act evictions, are Ellis Act evictions okay in Long Beach?
And the answer to that is you can do an Ellis Act eviction. You are going to have to wait until, by the way, Ellis Act eviction, for those people who don't know what that is, it's a permanent removal of rental housing from the rental housing market. So, for example, you have a duplex and you would love to just tear it down and build 6 condominiums with subterranean parking, and the duplex is occupied. You would be able to serve termination notices on the tenant, even though that unit is subject to statewide rent control. You have to pay relocation money. That relocation money is 1 month's rent, but you have to wait until October 1st, when my prediction that the statute will be over at that point.
Okay, Frame LA, can we ask new tenants for proof that they have been paying rent for the past year?
And the answer is the mayor has not set up any requirement that the tenant show proof of anything. So it doesn't matter that the guy's a pensioner and never lost his job. They don't have to show proof of anything. In that case that I keep referring to from my client that just started a case yesterday, where the tenant has $400,000 in a bank account, they don't have to show proof of anything.
They're talking about, Dennis, they're talking about when they're looking at different applicants, are they able to ask if they've paid rent for the last year? Ask for proof
They're
of
talking
it.
about applicants?
Right,
For
yeah, so they're screening different applicants.
Yeah, I think you can, certainly is a fair statement to show proof that you've paid, sure. But I don't think you can use that failure to pay due to COVID as a reason to reject the applicant.
Right, yeah. Okay, Evergrove, if a tenant does not qualify for the Rent Relief Act, would that help a landlord win a civil lawsuit in small claims court?
Well, then you're going to have to do a civil lawsuit. So either you can start an eviction based on the 25% that's owed for the transition time period. That's a straight standard eviction come October 1, or wait till November 1 and sue as a civil debt for all the money or all the rest of the money. So you could actually bring forth an unlawful detainer and also a civil lawsuit concurrently.
Okay, we have a couple different people with questions about when they can apply for the rent relief program. And so that, yeah, could you just tell us, are there any places where it's closed that you're aware of?
I'm aware that it's closed in the city of Los Angeles, so keep checking back. But otherwise, just apply and let them tell you that it's not open at this time.
Right, and you would apply even if you're in the city of LA. Since the LA one is close, you would apply
Yeah.
for the state one.
Yeah,
wouldn't you?
I've applied for, we have buildings in West Hollywood. Those, we actually saw some money come back through our management company, and also one property that I own in Studio City. That property, we have a tenant who's not paying rent, Dennis Block, believe it or not. And that person we applied, but the city is saying that it's not applicable at this time, that they're closed. Closed. What else do you got to do, Los Angeles? You can't open up this program.
Yeah.
So we're going to keep applying come next month.
All right. Well, hey, it's 11:45, and I got to make you a my famous blueberry shake for lunch.
Oh, thank you.
So maybe you can stick around for that. But anyway, there are so many questions, everyone. There are just so many questions. You can call Dennis Block's office there. You see that number 1-800-77-EVICT. He's serving Southern California. If you're up in Northern California, definitely go to the AOAUSA.com website and look in just search in the contractors and vendors, and you'll see a bunch of different attorneys that pop up there. Or look in your magazine if you're a member and you're getting the magazine. Take a look at that. Don't forget, 1 o'clock today, we're going to have somebody come and share about how you can get the most out of your insurance claims and limit your liability. So that's something that it's good to know it, and then you just have it in case something happens, and fire season will come upon us. And so that is specifically about smoke damage, and so that'll be a good one. Last week was ADA compliance with a guy that has over 36 years experience. You'll want to look at that one. Subscribe and join our email list. You'll get updates on different live streams that we're doing, different things that are happening. If there's a specific city where we need to rally and do something politically, then you'll be informed about that as well. And of course, we want you to join AOA, and so you can call in and get questions answered. And anyway, Dennis, thank you so much for taking time to be with us. And do you have any parting thoughts for us?
I do. I'm guessing that we're going to revisit this webinar towards the end of September,
Okay.
when maybe the program will be over and everybody will be itching to move forward with getting back their units and actually seeing some rent money. So once again, I appreciate the opportunity with the Apartment Owners Association to put on these webinars. I really do believe that we all get a wealth of information, not just from this one, but all the live streams that the association puts forward. And, I tip my hat to them for educating all the members. And Jeff, Dan, thank you very much.
All right. So thank you, everyone, again. Let's just go for it politically. Let's let people know that, hey, you know what? Landlords are people, and we should not be discriminated against, just like anyone else, and that this eviction moratorium is really a joke, and there's better ways to do it. So get out there, be politically active. We'll see you at 1 o'clock or next week if you show up then. Thanks again, everyone. Bye-bye.